Another easily recognizable feature of modern corporations is what we call limited liability, which restricts the losses that an individual investor can take to the amount of capital that they've invested in the firm. Now, limited liability has not always existed, and in some cases, some investors for firms were actually considered to be doubly liable, meaning that you could lose not only the amount that you had invested, but up to twice that amount in your personal assets if the firm declared bankruptcy. This was the case with many banks in early Canada, as well as in the United States. But it's worth noting that in most times and places, limited liability just did not apply. And that meant that when a firm incurred losses that were greater than its capital, that individuals who owned the firm were liable with their own assets for these kinds of costs. Now, that usually meant that in practice, organizations were owned by small, personally acquainted or affiliated groups that had social connections between them. The other alternative was simply that the organization was coordinated by a particularly wealthy principal, like the Manceps in a Roman Societates Publicanorum, or like a Nazir from in the 18th century BC. Unfortunately, these kinds of risks of unlimited personal liability tended to create a barrier to firm formation in various sectors, particularly those that needed to invest large amounts of money for long periods of time, which necessarily required many investors, most of which would not be directly involved in oversight, let alone allocation decisions themselves. So in order to reduce this perceived barrier that outside investors had regarding their degree of control and the information they would have about firm assets, corporate owners petitioned various governments to introduce a concept of limited liability. The idea here was, of course, that individuals should only bear responsibility for a failed firm's debts to the extent that they had invested, but no further, because they often had very little knowledge, let alone control of the situation that would have led to those losses. Now, of course, if individuals within the firm engage in fraudulent, negligent behavior or even criminal behavior, then these individuals are not shielded by the limited liability provisions and can be personally liable for their crimes in unlimited amounts. Now, the first time we see a limited liability being broadly enshrined in law is in 1911, when the state of New York granted limited liability to manufacturing firms. Not to be outdone, by 1855, Britain had granted limited liability to any public corporation which sought it, helping to spur on the Industrial Revolution in Britain, and then, of course, the manufacturing boom of the 19th century in the United States. Now, there is a related concept to limited liability which receives particularly thin attention, and this is the concept of entity shielding. When we think of limited liability, we think of how the owner's assets are protected from a failure of firm. But entity shielding points out that firms are also protected from the liabilities of individual owners who might become bankrupt. In this way, other owners or other participants in the firm don't have to worry about the creditworthiness of their co-investors. Under a situation where there was no entity shielding, each individual investor would not only have to assess the creditworthiness of their operations, but the creditworthiness of all of their partners, lest their own assets that are invested in the firm become exposed to the cost of individual defaults. Finally, we have to consider the possibility that limited liability can be used as a way for firms to protect themselves from the true costs of their activities. Limited liability is often lampooned as providing for private profits, but public losses, in the sense that private investors whose businesses do not fail accrue all of the gains of it. But in the event that these end up disaster, potentially harming other people, these investors can only lose what it is that they've put in. Meaning, of course, that outsiders who are harmed by firm choices might not have the opportunity to fully recoup any kinds of damages against them. This is made particularly challenging when you have firms that operate as individual subsidiaries in different nations, because these subsidiaries are individually capitalized, and therefore claims against the subsidiary, will be limited in most cases to the capital that is invested in that particular subsidiary. An interesting problem like this emerged in the case of Texaco and Ecuador. Texaco, an oil company, had been involved in extracting oil in Ecuador, but had systematically despoiled the country's environment. The nation's courts ultimately found them liable for $9.5 billion worth of environmental damages in 2011. But by then, Texaco had merged with another firm, Chevron, in 2000. And Chevron denied any responsibility, and in 2015 was able to successfully defend against claims that their subsidiaries around the world could be held responsible. This was tested in a Canadian court when Ecuadorian prosecutors attempted to seize assets in Canada belonging to Chevron in order to recoup their costs. A similar sort of arrangement occurred in the case of Union Carbide's Bhopal plant, which exploded in 1984, killing thousands of people. Over the subsequent decades, hundreds of thousands of people have been shown to have been poisoned by the negligence of the firm and its managers. Now, in response to the Bhopal disaster, the company only ended up paying out $470 million worth of damages. If the damages had been assessed proportionally to how Union Carbide's liability was measured in its asbestos case in the United States, the damages awarded would have been in the range of $10 billion US, vastly more than the capital that Union Carbide's Indian subsidiary USIL actually had. Because the firm was seen as being still useful to the government of India in terms of being able to pay taxes, the firm was not completely dismantled, and they neglected to pierce the corporate veil and pursue Union Carbide back in the United States for any further damages beyond what had been awarded against USIL. So these are limits that we run into in terms of limited liability that ultimately end up protecting shareholders, but in some cases end up protecting firms engaged in corporate malfeasance. And this is a real challenge for us to sort out in the modern world as we attempt to delineate where exactly the responsibilities of shareholders end when it comes to the behaviors of the corporations that they own.